Okay, yeah, my name's Dennis Collopy. I'm probably one of the few people here who's actually not a lawyer, but my background is actually in copyright as a practitioner. So I've come from the music industry, worked in there for several decades, but before I came into the music industry, I was a computer programmer. So and one of the first things I learned that there was a correlation between how rights were protected and how they were remunerated, principally through databases. And that's one thing I'm blessed from having learned at Marconi. We were one of the first people to kind of launch, early versions of databases. I mean, in those first years in the music industry, I learned that databases matter. And this will become quite evident later when we talk about things like training data. So that's kind of my motive for doing this. In my kind of recovering music publisher role, working predominantly for the Intellectual Property Office over the last 10, 12 years, I've done studies on social media and intellectual property, latterly metadata, which is very core to us. But principally, the AI work we did, which I'll talk about shortly, is something that was commissioned in 2021. It was around that time that WIPO actually introduced the whole kind of, if you like, call for paper. There was a scoping process where a lot of contributions, some of which we've actually referenced in our study. And it was a really good time, but this all predates Chat GPT. So it was a different world then. So I hasten to add that some of the findings you may feel slightly out of date, but I still think they're relevant because they talk about enforcement. Enforcement hasn't really changed a great deal. Almost everything else, of course, has. And we delivered these findings to WIPO last year. And principally, the project aim was to review and collate the literature and capture the views. We did over 50 interviews of those with expertise and experience in the existing IPR enforcement landscape. What we wanted to do was, how is AI currently used by rights holders to protect and enforce? And also assess threats from those infringing IPR, which we'll probably wait until the end till we actually get into why that actually matters. And the research covered 5 different rights: patents, trademarks, designs, copyright, and trade secrets. And I'm reliant on certain experts in this room for some of the trade secrets information. It's a 2-phase project. We critically examined the AI and IP enforcement literature across all 5 IPR. And then that led us to create a questionnaire for the different interviewees, and involved stakeholders, obviously from industry, the enforcement agencies themselves, academia, legal practitioners, and the judiciary, I should add. We wanted to define AI because there were a multitude of different definitions. And I'm grateful for my colleague, Professor Kevin Curran, for this really simple sentence of definition: human intelligence exhibited by machines. That's how he defined that. Because we got lost. I mean, I think we probably spent a month actually trying to define AI. There were just so many different definitions. And that, for practical purposes, is one of the things that we actually use here. Oh, sorry, you lost me. Where's it gone? There you go. Right, I'm back. So our research focuses on a form of narrow AI, a form of machine learning. That, for all intents and purposes, is the form of AI that we're actually using. And that obviously learns from experience to find patterns in a set of data. This we took from IBM. So narrow AI is the only form of AI that exists today and is trained to perform a single task. And unlike general AI, cannot operate outside of that defined task. And again, quoting IBM, any other form of AI is still theoretical. And ChatGPT is a classic example of a narrow AI. We also talk about non-transparent AI, also commonly known as black box AI, which cannot be inspected in the same way as systems with a full audit trail. This happens to matter a great deal when we get into the detail later on about the evidence base. So our research findings. So the main opportunities, I'm going to cover these by different sectors. In copyright, there's obviously an opportunity for increased use of AI tools at scale. Copyright industries have been pretty successful in doing so. And as a filtering tool, AI helps identify content and reduce human workloads. But it requires accurate and adequate training data. The best example of the one that is currently being deployed is YouTube's Content ID. And it's not 100% successful, and we should stress that. And that does mean that there are some unintended consequences from its misuse, if you like, by certain actors. But we figure out, according to the data that we found, it's about 96% successful in identifying works. And you're talking about the tens, if not hundreds of millions of takedown notices issued every single year. That's a pretty good statistic all the same. For designs, clearly the improved image recognition capabilities. I'm relying on Stuart Russell from Stanford, who actually argued that actually one of the biggest developments in AI is the ability to improve image recognition. It has improved by an order of magnitude in the last decade. This really is very important for designs. We saw the trade body Anti-Copying Design maintaining a database of over 300,000 designs, including unregistered designs that could provide data to train an AI to recognize infringements. But as we've learned from early on, that figure of 300,000 pales when you're seeing the number of new designs that are capable of being created. Sorry, I'm struggling with this. I'm a Mac user, sorry. I didn't do well with this. Okay, I'm okay. Yeah, it probably is easier. Okay. For trademarks, there was general confidence in the ability of AI to assist here. This came from a number of different sources, particularly the local sources, ACG, and obviously from the EU IPO. The idea that AI tools can actually help trademark enforcement is really overdue. We also saw that from the marketplaces. For example, Alibaba in China actually regularly use AI to identify counterfeits on their platform. And it's been used at scale probably for the last 6-7 years. Also for design rights, by the way, they use it to identify infringements there. Trade secrets, especially for AI-related inventions, need enhanced protection against misappropriation. And again, I'm relying on Kevin to say that security measures such as AI-based techniques, such as neural encryption techniques, may offer greater protection. So in summary of the opportunities, detection of copyright infringement is the most common example of AI use at scale, provided you've got robust training data sets. In a similar sense, if they're used in a similar way, AI could be used to identify design and trademark infringement and considerably reduce human resources. We believe that there is scope for AI to actually develop IP analytics. This is actually a really could be a valuable emerging field where we start to see patterns emerging. It's certainly what the platforms are using to identify counterfeits. So the example again being Alibaba, they actually recognize the value of building a data set of analytics, highlighting where infringements are taking place. So AI can only improve and become more accurate and faster, detecting patterns in a far superior manner to humans. And its overall value is as a filtering tool and an aid to human analysis. I need some water. Sorry, just miss these. Any water? Going to need this because the challenges are quite long. And I'm going to have to speak fast, I suspect. Thank you. Thanks. These, for reasons which become obvious, are now in black. There were widespread concerns about the cost and resources in the copyright space for using automated tools at scale. This really does disadvantage small, medium-sized enterprises in a very significant way, and therefore places greater reliance, for example, in the music space, on collection societies to actually do this. Automated anti-piracy systems, it's a bit of a mouthful, are opaque and reliant on hard-coded automated rules using dynamic, potentially unpredictable and non-transparent algorithms for decision-making. This is a very serious concern for us in terms of identifying content. And there are myriad examples of where content has been misappropriately identified. And the most famous example I can think of is Edwin Collins, who put his own stuff up on YouTube, only to have it removed because someone else had claimed it somewhere else in the world. It was absurd, you know, and we saw this quite a lot. But it's the ability to appeal, and I still think this is something that's going to come into the narrative when we talk about the impact of the both the AI Act, but also Article 17 in the European Union. For designs, definitely interrogating registered design databases. It may not help identify infringements of unregistered designs and those reliant on copyright. You know, apart from the ACID database, the costs involved in using AI to identify infringements benefits large firms owning portfolios of designs. That does not necessarily represent the design community, certainly not in the UK. And also, we should recognize that computer-aided design is inbuilt in design courses in higher education. You know, I share an office with someone who's a designer at my university. It says it's inbuilt in terms of how designs actually work. We're using computer software all of the time. So it stands to reason that AI is going to play a part in terms of new designs that are coming to market. Trademark enforcement has been hampered for most of this century by data sharing issues between industry, government and enforcement agencies. It's a real problem. I mean, when we did our study on social media IP 10 years ago, that was the biggest single criticism of that. There's a willingness for people to enforce, but absent reliable data is very, very cumbersome, very difficult. And the trademark enforcement agencies themselves struggle to extract clean data from infringing websites and collect sufficiently large data samples to actually police and train the data. The patents, obviously, the use and enforcing patent rights needs to blend of human and technological knowledge, the complexity of language involved in the application of patents, as well as complexity, cost, and effort taking legal action are principal challenges to enforcement. Restrictions on using evidence of reverse engineering in English court proceedings make infringement of certain patent rights difficult to prove. AI-generated or assisted IP infringements must relate to the actions of a legal person, and as such, enforcement needs to be taken against those operating the AI. And enforcement against infringement related to AI may be hindered due to uncertainties associated with black box AIs. And I think this really is a problem for us, because we're seeing AIs being developed that actually defy human comprehension, when one of the biggest technology companies actually, with major investments in this space, actually admitted he didn't actually understand the nuances of some of its own black box AIs because they've been created by other AIs. The tools are perceived as insufficiently nuanced or adapted for patent law, and I think that speaks for itself. And finally, trade secrets. The enforcement is impaired by the perceived risk of public disclosure. And obviously, infringement issues, and this is particularly true in Europe, we notice, where we've got most of this from are commonly settled out of court. And obviously, there's the key thing is enforcement of trade secrets is impaired by uncertainty about what may legally constitute a trade secret. It's obviously AI is seen as one of the relevant factors in the increase of cyber thefts of trade secrets. This came from the US. And in turn, that requires new AI machine learning tools to combat cyber attacks. I think the rest kind of speaks for itself, but I think that the whole trade secrets area, I think, is one that we found challenging. And I want to echo what Tanja said, which is the whole area of trade secrets and patents needs to be really carefully reviewed. This is I think it's a really important thing because there may be unintended consequences if that's not carried out. We noted ethical issues. And the principal one has to be the quality of the training sets, whether they're adequate or complete. And there's no question these training sets they affect the decision-making processes. They also reflect systematic and inherent human biases. And there's multitudes of examples that people have given before. And the imperfections in the technology itself, including the lack of transparency as regards black box AI and accountability. When we can't actually explain how the AI works, I think we should be really, really concerned. We've seen plenty of examples where inflexible decision-making processes, particularly in the copyright realm, can lead to overzealous blocking of legal content. Obviously, the AI needs to be trained to meet the needs of different IP laws. And the classic one of maintaining GDPR compliance when training data uses mass volumes of personal or sensitive data. And there is the real danger of bad actors using AI to constantly re-upload content after it's been removed by takedown notices. One thing we've learned from the counterfeit space is the bad actors, that's the Google expression, are always one step ahead of enforcement. We should never underestimate the ability. This technology is free for anyone to be able to use. So, yeah, in summary, the main challenges are the quality and quantity of training data needed for the effective use of AI and the crucial ethical moral issues involved. AI is incredibly resource hungry, and there's a clear link between the volume of data used by the AI and the accuracy of the results. The volume, quality, and currency of data is the most common concern. The training AI tools is time-consuming and requires constant updating. Yeah, for us, we believe that AI should currently only be an initial tool for flagging content to human analysts for verification, rather than for enforcing IP rights independently. And so, conclusions. And more water. As you can see, the bits in black, overall, the number of challenges, in our view, exceeded the number of opportunities. Maybe that's because the number of fundamental issues relating to the enforcement of patents and trade secrets. But there are other concerns, and I want to flag these, some of which you're going to be quite familiar with. It's not new. There were warnings back in a really important Princeton study in 2022 about methodological issues related to the use of machine learning in the quantitative sciences. The post office scandal, which I think will resonate with everybody, hopefully, in this room, suggests that we should be really careful about the dangers of humans blindly accepting the output of automated systems as reliable evidence. And that's something I really believe quite passionately. What it's also led us to is express a concern about organizations reducing technology resources, outsourcing critical expertise, and adopting less suitable auditing processes. This is the great example from Australia about robo-debt. described as an AI ethics disaster, where they attempted to improve the tax payments in Australia by a factor of 40-fold increase. They went from 20,000 annual examinations to 800,000, but in doing so managed to accuse the vast majority of people of underpaying their tax. It became a complete and utter disaster. Kevin's also asked me to stress this thing, the emergence of adversarial machine learning where bad actors can exploit vulnerabilities to exploit systems is a really important issue for us to be aware of. And they can alter the behavior to serve a malicious end goal. This includes poisoning of the training data or evasion attacks, many of which go unnoticed until there's a machine learning critical failure. All that said, we remain confident in the ability of machine learning to offer scalable solutions to assist the enforcement. But we simply can't recommend the adoption of the technology without really stressing the significant caveats that we've just described. And we recommend any new AI-based IPR enforcement system has to be carefully piloted to remove that. And that to remind you about the post office scandal where people simply didn't prove that. Thank you.
Thank you, David. So, questions? Do a tick, don't you? Dave.
The box that scans the web looking for infringements, at what point does the validity test kick in? Did you look into that? So whether the right being enforced is actually valid. Trademarks usually will be, designs often won't be.
We didn't have any real evidence in design. I have to say that the design rights aspect is probably the weakest part of our research, and that's principally because the agency that deals with it was not really happy to kind of really comply or cooperate with the project. That said, we have sufficient evidence from the literature and from other people we spoke to suggest that design rights could be treated much the same way as copyright, in other words, at scale. But I think it's no coincidence that we see the number 4% perhaps in copyright. It could be much higher. I'm Stuart Russell, who I spoke to, who's been a very famous kind of expert on this. Stuart Russell was very clear. He said, image recognition is probably one of the greatest developments of AI at scale. He said that's where, as opposed to large language models, where we still see the flaws every time you're using Facebook and you're watching the narrative going, I'm sure they're not saying that. It mistakes the word. But image recognition is much, much more reliable. And I remain confident, and not just hopeful, but confident that actually suggests design rights infringement enforcement could be actually improved, really do. I mean, you're talking about almost 98% perfection in terms of image recognition. And he said it's going to get to 100%. It is going to be really, really masterful. But we know hallucinations happen. Thank you.
What about in cases like in patent law, where you could actually have the AI system train up to the priority date and give them the prior art, and therefore you could ask questions such as inventive step. You know, is it able to come up with a claim there, avoiding the hindsight bias that we typically have, right? Where you can say, okay, the AI, the only information that it had was prior art. It didn't peek ahead. And so that could give you potential for invalidity claims, so saying, based on these three documents, the AI was able to combine them, and here we have the claim. Do you have a view of uses like that to show, hey, this was part of the prior art. This patent is invalid.
Well, my view is all enforcement, as long as there's a human actor involved in the process, it is great to use. I think we should use it, and it's only going to get better. This technology is only going to improve. But I stand by this. Using any form of AI at scale without human intervention or supervision is a very, very bad idea. And I think from a pattern point of view, and I take it's Philip Johnson from Cardiff who said it's like the human must remain in the loop at all stages, and I stand by that in enforcement as well.
Yeah, and to reinforce that, I mean, you shouldn't forget, when you think about inventive step in patents, yes, of course, we're all trying to eliminate hindsight bias, but at the end of the day, it's a value judgment. There is no such thing as a right answer. It's a value judgment as to what you think is sufficiently inventive as opposed to being sufficiently obvious. And I would say at the end of the day, that is an irreducibly human exercise. Anyway.
So just kind of following up on from that. So if we then aim to retain a human in the loop, now I can see how that perhaps is useful to address hallucination problems or things where AI just gets something obviously and blatantly wrong. Now, but if we are exercising normative judgment, are we not likely to leave that normative judgment eventually to the AI and then end up the human in the loop is simply a scapegoat or some sort of illusion we're presenting to ourselves, where in the end the decision is not made by humans, right? I mean, you can point to use of AI where targeting individuals has been done by machines, and the question, there was a human in the loop, but that human had 10 seconds to decide whether or not that decision was going to be acted upon or not.
Well, can I just show you the next slide? It was the final slide because it sort of answers that question. Because, and this is my personal update on that. So I've lived in my home for 40 years, and it's an illustration of databases. And every year, a letter arrives from the Wine Society addressed to the previous occupant of the house. If that doesn't illustrate what's really going on, it's like, and also we have 250 different databases, all repeating and duplicating the same information, and yet catastrophically, most of them don't agree. And if that doesn't illustrate the problem, the mindset that we've got, that, and there was one of our interviewees on a different project, but it's relevant to this, said the systems are not the problem; it's the humans that are the problem. Because it's human inputs when you're relying on data that's provided by humans. Now, you could get to a point where the AI does all the data collection, and it probably would be perfect. But that's not going to happen. If the data is, for human-related IP, such as music, comes from human beings, if that data is flawed at the beginning, it could go garbage in, garbage out. You're never going to get a good outcomes. And this thing here,
it's worse because your databases are going to fill up overnight as soon as you have AI-generated works being included.
And that's what we're struggling with now. We have 200 million sound recordings officially. I heard a figure the other day. It could be 500 million by the end of this year, and no one has any idea who wrote those. But there's money being generated and somehow distributed. It's potentially catastrophic.